Hi, this is Diane Cohen with MacroPro. I'd like to welcome you to our webinar today. Today we are covering the very important topic of medical fee schedule. It is new and it's a topic that is going to be very controversial in many aspects because there are so many different ways that a AME, QME can bill. So we want to make sure that all of it is appropriate and that we understand their billing. So before we get started with this presentation, I would like to say just a few things. First of all, your certificate will come to you within the next 2 hours. It'll come to you from GoToWebinar. Please make sure that you have logged on to the program today and that you're not just phoning in. Those who just call in will not be able to receive a certificate. So please be sure that you log on so that your time and attendance can be recorded. Secondly, there are handouts attached to the control console, so please be sure to download those so you have them for your references in the future. And then lastly, if you have any questions for our expert today, please write them in the question section and somebody will read them to him at the end of the presentation. Now, I would like to introduce Bill Barthel, who will be speaking to us on the new medical fee schedule. So Bill, thank you so much for joining us today.
Let's jump right in. There's a good MacroPro screen. For Bradford and Barthel, this is just some information on how you can contact us on all these social platforms. We try to maintain a presence everywhere. Tammy, who you just saw, is in charge of this stuff. So if you ever need us for anything, you can look us up there. We also have blog articles. We did considerable amounts of training with COVID. Especially when nobody knew exactly what was happening. Bradford and Barthel was there for training and to really kind of lead the way with legal representation. At any rate, hey, there's me. And you know what? I have a red face there too. I think it's me. Maybe I need my blood pressure checked. I don't know. Anyways, that's me. Importantly, look at the email address. I got a lot of material to get to, and invariably, you guys may have some questions. And if you do, please email me. I'm happy to help. It takes away from the drudgery of my normal caseload. So I'm happy to answer any quick questions and help you along with any guidance you may need on this topic. It's still relatively new and it's somewhat troubling. So, okay, so let's get right into it. So on April 1, the changes were implemented, as I mentioned before. And, there's been no changes since 2006. So, we're talking 15 years, and it's probably high time that some changes were made. I don't think that all of us on the defense side necessarily agree with them. I think some of the doctors are happy with it. But just to give you a little bit of background, when they were preparing the changes, they were holding public forums and they were issuing statements. And one of the statements just gave some background as to what the new regulations should effectuate. And the goal, as it says here, is to improve the delivery of medical legal evaluations expeditiously and equitably. There's some early assonance for you, not alliteration. And what they've discovered recently is that in doing some studies, the system is being abused. And for many of you who run a desk and for employers for sure, you guys all can recognize, yeah, the cost of the evaluations was just skyrocketing because it was strange and kind of subjective. As it states here, it says, in addition, the aggregate spending for medical legal expenses increased by 46% over the course of 5 years. So that's just too much. Part of it is a recent trend in litigation. I have a friend and colleague. His name's Bill Tappan. Real good guy. I like him. You may have run into Bill at some point. But Bill really started representing QMEs and AMEs to get payment. And as a result, there was a substantial increase in the amount of disputes which were occurring. And because the prior system was based on those complexity factors, I don't know if you remember those, you can wipe them away from your mind now, but the complexity factors were arduous and they weren't administered uniformly. And so I think what the DWC saw and thought is, okay, we need to solve this problem. We need to come up with some objective criteria which will be easier to calculate payment and should take away from the uncertainty and as a result reduce litigation. The problem is that they're definitely going to result in increased costs. So again, it's adding some objective criteria, which will allow for uniformity, but it's absolutely going to cause some problems in other places, as we'll discuss a little bit later. One of the interesting word choices, you know, I like words, I'm an attorney, I read books, and one of the things I always found interesting in this statement is that the goal of the new regulations was to reduce frictional costs. Again, I think the idea is, you know, if we can eliminate litigation, it's going to be better for everybody. And that's all well and good, but, you know, as an attorney, as you guys out there who are either working a desk or employers, frictional costs are part of the problem, probably because of attorneys. And I know that this will alleviate some of them, but they're going to certainly result in other costs. For example, I mean, we're going to reduce frictional costs, but there's going to be an increase in actual costs based upon the increased flat rate fees and the per page charge, which I'm sure you guys have heard of. Maybe you've even had to work with it already. So again, the problem really blossomed over the course of the last several years as QMEs were starting to complain, and appropriately so, that they weren't getting paid or they weren't properly being paid. As a result, there were some attorneys who took, Bill Tappan, one of them, who took on representing them, and the attorneys were recovering substantial amounts of attorney's fees, oftentimes far exceeding the outstanding balance that the QME had. And I think more than anything, that's what really raised the red flag to the DWC. I personally had 9 trials on that issue. And with each case, the judge would look at the other attorney and say, okay, Mr. or Mrs. So-and-so, you have a bill that is now, your attorney fee bill is higher than the QME's bill, and that just doesn't make sense. So I think all of us got kind of tired of it, and changes were made. But the changes are going to increase costs. There's just no doubt about it. The WCIRB, as it states here, offered some projections as to what the increased costs are going to be. 11% increase in record review costs for the QMEs, something MacroPro is intimately familiar with, and 22% overall increase to med legal costs. Overall, I mean, there's some big numbers here we're talking. They're projecting potentially increasing costs from $384 million up to $469 million. So funny, we're you know, decreasing the frictional costs, but we're adding actual costs. That's what we do, I suppose. One of the biggest cost increasers is the missed appointment fee, which we'll talk about in detail. Maybe you guys have already ran into this. I know I have, and I'll talk to you about it as we get there. And here's where I've already jumped ahead one slide and said it increases actual costs. I quote here Dave Belushi, he's a WCIRB Executive Vice President. And one thing I thought it was interesting that he actually said, and this is a written statement, he said the providers, meaning the doctors, think that it's not enough, but on the carrier side, that's us, or most of us, think that maybe it's too much. So we'll see. So that's kind of scary when you leave it open like that. The good news is they're going to monitor it. I'm anticipating that they're going to have some tweaks to it. I would hope so, because the new system, in my opinion, has a high potential for abuse. And if you followed it along, you probably know what I'm saying already. But again, we're going to talk about that. But we're going to get right into the actual statutes now and when it started. So this is 2 months ago on April 1st, April Fool's Day. A significant day in my life, but that's a whole nother topic. Pretty much now, anything you deal with is going to have the new fee schedule. Before, it was any appointments, any medical, legal, in-person evaluations after April 1 would be subject to the new fee schedule. But any supplemental reports without an in-person evaluation, if they were requested before April 1, would be the old fee schedule. But candidly, I mean, we're you know, more than 60 days in, so if you haven't received a report that you requested before April 1, you got other problems bigger than fee schedule. So pretty much everything now is going to be on the new fee schedule. I did the next 2 slides just as an overview. Maybe you flag them on your computer, put a little piece of tape there or a sticky note or whatever you have to do. This is just a quick reference. These are the new base rates, the new flat rates for certain evaluations and medical legal testimony. As you can see there, there's the missed appointment charge. We're going to talk about that in a second. And again, this is just a quick listing of the changes that have been made to the fee schedule. In addition to this, and again, we're going to go over this in detail, so if you have questions, hold them, we'll get there, I promise. There's modifiers now. So the modifiers, as you can see, can substantially increase the amounts that the QMEs are going to be able to charge. Pay particular attention to the psychiatrist-psychologist, which says that any base rate is doubled. So that concerns me that I'm going to get a lot more psych components added to my claims, perhaps as a bargaining chip from the applicant's counsel. Okay, so let's step away from the general and go into the specific. This is the first substantial change, and honestly, it's the one that I've already seen in practice more than anything else. This is the missed appointment fee. Before, when an applicant missed an appointment, the doctor would understandably be upset and probably try to get some money from the defense. Sometimes the defense would pay, sometimes they wouldn't. There was some, there was ambiguity to it. And one thing that I think is a good thing is that now there is a certain cost, and it's $503.75. And if there's a missed appointment, which occurs within 6 days before the evaluation set to go forward. And this could be over anything. So maybe the interpreter can't show up, which is unfortunate for the defense to pay for that. But, or if the applicant's attorney directs the applicant not to show up, or as just happened in one of my cases, the applicant's decided that he's tired of going to doctors and just didn't show up, the doctor is going to be able to charge $503.75 for the missed appointment. And so, as I mentioned, this one I've seen a couple times now. And understandably, the doctors that I've encountered are unwilling to reschedule until the missed fee has been paid. So there's also some disconnect, I think, right now with bill review companies. I don't think all of them are necessarily aware of this change, but it's a big change, and you need to get on the same page, because any missed appointment is going to be charged, and you're not going to be able to, you're not going to probably be able to move forward with your medical legal evaluation until that is resolved. In this slide, I referenced the fact that if the physician produces a record review, meaning they obviously didn't see the applicant, but they reviewed records submitted, they could bill separately for that. We're going to talk about all that, the per page thing. That's the thing that's scaring everybody, understandably. But here's the good part about the missed appointments. So here, I'm going to skip right here. This is something that's new, and it's kind of nice for us, because again, before, sometimes our defense clients would either pay or not pay, but they really had no recourse to recover that money. And now there is a change that favors the defense side with this. And so if the fees for the failed appointments or for late cancellations are incurred because of the attorney or because of the applicant, the defense can now potentially get a credit for that. So, and that's a credit that's going to go against the applicant's ultimate compromise and release award, or presumably F&O. Again, this represents a pretty big change, because before we couldn't really do anything. We try to get credit from a CNR, and judges who lean applicants towards the applicant sometimes run towards the applicant, but judges almost always said no. There was, unless it was an egregious, maybe multiple missed appointments or something egregious, you almost never got a credit. But now we have a statutory basis for it. You should know this, the statute is permissive. It just says the defense may. It doesn't say shall. So it's not a slam dunk, but it's a statutory legal basis for us to file a petition for credit, which is something I've done now twice on cases. If nothing else, it just notifies applicants' counsel that I know the law and I'm going to take advantage of everything I can, and you should adhere to the requirements for attending medical legal evaluations and act responsibly. My recommendation is that you submit a petition for credit and a potential proposed order to the judge. The judge is almost certainly going to allow the applicant's side to talk and to maybe explain why there's a good reason why they missed the appointment, but put the burden on them. Get that thing filed and put it on them. Okay, so now let's get into the types of evaluations. So now there's 3. We're going to go into each of them in some pretty good detail. The first, and the one that you're going to get right off the bat, is a comprehensive medical legal evaluation. That has a flat rate of $2,015. So the comprehensive medical legal evaluation is certainly your initial evaluation is going to be billed under this category. It can only be done once every 18 months. So there's another category we'll talk about. It's called a follow-up medical legal evaluation. But for any initial any initial evaluation, it's going to be billed under this. As it says there, and as I've already stated, it can only be billed one time every 18 months. To get into the statutory definition just a bit, I'm not going to read all of this, but the statutory definition says that this type of evaluation includes, importantly, an in-person examination of the applicant, results in the preparation of a narrative medical report, and is performed by a Q.M.E, an A.M.E, or a PTP. And as you may know, unfortunately, PTPs can sometimes be considered medical legal evaluators if they are issuing a report which proves or disproves a disputed fact. So for the most part, the PTP should bill under the for treatment. But on occasion, if it's a narrative report which specifically addresses an issue, perhaps it was requested by one of the parties, a PTP can bill under this code. I would suggest for those defense adjusters out there, you be careful for PTPs who are billing under this code all the time. That's not permissible. It's only under certain circumstances. Again, it's an in-person evaluation and can only be used by the same physician twice within 18 months. So that's same physician, same body part, I should say also. So for example, say that you have an orthopedic injury with a psych overlay. The psych med legal is selected. That first evaluation will be a comprehensive medical legal evaluation. Say for some reason down the road, as seems to happen often nowadays, the psych component also has a medical legal evaluator. That first evaluation with that evaluator will also be a comprehensive medical legal evaluation. As you may recall, it's going to be doubled because of the modifier, but I'm jumping ahead of myself a little bit. Okay, so here's where we get into the scary time stories. So the 200, there's now a charge, a $3 per page charge for documents. I'm going to cover this more in depthly. Is that right? I'm not sure, but I'm going to cover it better later on in the presentation. But for now, know that 200 pages are included in the 200 pages of record review are included in the comprehensive medical legal examination. So if you provide the doctor with more than 200 pages, for page 201 on, the doctor may bill at $3 per page. I'm going to talk a little bit about what constitutes a page later on, but this is certainly where the costs are probably going to skyrocket. Okay, now on to number 2 type of medical report we have now, which is the follow-up medical legal evaluation. This is, it has a flat rate of $1,316.25, and it's limited to the follow-up medical legal evaluation within 18 months after the comprehensive. So under these circumstances, this is when you have the comprehensive medical legal evaluation. Say the applicant has to have surgery. 12 months later, he's had surgery, he's recovered, and it's time to hopefully get a PNS report so he can settle the dang case. This is what you would ask the doctor to prepare, and this is what you would pay him, $1,316.25. There's also the per page document, which we're going to, per page document charge, which we'll talk about in a second. Again, the statutory stuff here, it just says this is the follow-up medical legal evaluation. Again, this is one of the 2 evaluations which actually is an in-person evaluation, results in the preparation of a narrative report, and is basically done within 18 months of the comprehensive examination. As I just mentioned, there is also 200 pages of record review, which is included in the base rate. So if you provide 190 pages to the doctor for the follow-up, then all you should be paying is for the base rate. All you're going to be paying at that point is the $1,316.25. By the way, why the 25 cents? Aren't we getting away from pennies in our world? I don't understand that. Would have been a lot easier. A lot of numbers. Anyways, if you only provide 190 pages, that should be contemplated within the base rate, and the doctor should send you a bill for $1,316.25, nothing more. If there's pages that are say the applicant had surgery and now there's a ton more of Kaiser records or something associated with the surgery, those documents are all going to be billed from 201 on at $3 per page. Okay, this is the third kind of reporting. There's only 3 now, which is good. Before there was the ML 101 and 102. You guys always got the ML 104 because which was supposed to be reserved for complicated cases, by the way, but eventually every carpal tunnel injury became a 104. At any rate, this is the third type of report. This is the supplemental medical legal evaluation, and the distinction with this one is this is basically a record review. This does not include an examination of the applicant. So maybe you sent the Q.M.E. records from prior surgery, or maybe you subpoenaed some records and the applicant was a former trapeze artist or rock guitarist, and you want the doctor to comment on those records. The doctor can review the records and now will be able to charge a flat rate of $650. If you look down at what I've written down here, I add some italics. Italics are important. It's critical because these are records that were not available at the time of the initial follow-up, or I'm sorry, initial or follow-up examination. So for example, say when you first requested the comprehensive medical examination, you had a bunch of records from when the applicant was a trapeze artist in the circus. You had 400 pages, and you sent them to the doctor at that time. And the doctor didn't review them. They were on his desk, but for some reason, the doctor didn't review them. Well, now the doctor's got to review them, and he or she cannot bill for them because those records were already provided and they were made available to him or her. So there are certain circumstances where a supplemental report may be required of the doctor, and the doctor may not be able to bill for it. Again, the statutory language, the big distinction is there's no examination of the patient. It's again basically a record review, and down under sub D there, it's performed by the Q.M.E, A.M.E, or the P.T.P, as we've already discussed. Now, this one's got a little bit different document threshold. For the comprehensive and follow-up, you get 200 pages contemplated in the base rate. For this one, you only get 50, which I suppose makes sense because the supplemental is designed to review records. So it makes sense that the record review threshold would be lower. So if you only send 45 pages, then the doctor can only bill the $650 flat rate. However, if you send 51 pages, from 51 on, the doctor may bill at $3 per page. So as I mentioned earlier, sometimes the doctor may not be able to bill for this. I already gave you the example of the circus records that were available to the doctor at the time of the initial evaluation, but he or she didn't review them. The other instance where a doctor may not be able to bill for this is where an issue wasn't addressed. So to use the circus records, I like the circus, it's fun. So to use the circus, as long as there's no animals, by the way, animal circuses are not good. Anyway, sorry, I'm getting political, let's not do that. To keep with the circus theme, so say that you sent the circus records to the doctor and with the comprehensive evaluation, and the doctor said, I reviewed 400 pages of circus records and the applicant worked as a trapeze artist and reported no injury. So that's reviewing the records that were made available to him. But say you specifically ask the doctor, comment on how the applicant's work as a trapeze artist affected his lower back injury or may have affected his lower back injury, and the doctor doesn't. The doctor just summarizes the records. Well, the doctor didn't address the issue that you wanted addressed, and he or she has to. So under those circumstances, if you've been very clear in what you've asked of the doctor and the doctor hasn't been responsive, the doctor may have to issue a report which addresses your previously requested issue, and the doctor may not be able to bill for it. So what I put here is really important for you folks if you're in pro per, or for I'm sorry, if you're not litigated, or your attorneys. Make sure the advocacy letters are very clear. I know advocacy letters kind of took a hit with the Maxim case. That's a case that said that basically the doctors have to find out the information, and that the advocacy letters shouldn't provide too much information to the doctor. But with this latest change, I think sometimes we're going to have to be a little clearer with the questions we want addressed, and that may involve setting a context of the facts. So I think advocacy letters are going to come back a little bit, and I think it's important for us, certainly as attorneys and as defendants, or even applicants' attorneys, to be clear with what we're requesting from the doctors. So I actually think I already gave you this examples. There's a big red no. We can kind of skip through these because as I want to do, I've already talked about it. So sorry if I confused it. But again, it just make sure that the doctor is provided with both the records and the issue that you want the doctor to address. So again, so if the doctor is unwilling to issue a report because he or she knows that he or she can't bill for it, well, that's going to be a problem for them, because under these circumstances where a report is properly owed, but the doctor is unwilling to give it, the doctor has to. And it's very clearly stated in the new statute that failure to issue a supplemental report upon request because of an inability to bill for the report can constitute discipline actions by the administrative director. So the doctors know this. Again, I think if we're very clear with all of this stuff, it'll make for a smoother transition. Okay, so those are the three types of reports, and now we move into some other types of areas. The deposition testimony, as you may recall, prior to April 1, we were required to pay expert witnesses, doctors, for the doctor cross-ex, $250 per hour for their testimony, and also $250 for preparation. They were entitled to 1 hour preparation, 1 hour testimony. We had to pay them $500 in advance before a deposition could go forward. Well, that's been increased. The medical lobby was successful in this one, and now it's $455 per hour. So before you have any cross-ex, you're going to have to, what's the math on that? Blah, 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 $910. You're going to have to pay to any doctor in advance of a cross-examination. Interesting here, and I have something in italics and I didn't address it, which is not what I'm supposed to do. But what I thought was interesting about this statute, and it's in another one too, they allow for the doctor to bill his or her hourly rate, but it has to be either $455 or the doctor's hourly rate, whichever is less. So I'm guessing you will never see the doctor's hourly rate. You're going to see $455 per hour charged. I can't imagine a doctor is going to say, hey, you know, I'm feeling good today. I'm going to bill $100 because I like working. Anyways, moving on. So again, as I just mentioned, they have to be paid a minimum of 2 hours before the deposition can go forward. So if the defense is setting the deposition, you're going to have to cut that check if beforehand, and if the applicant's setting the deposition, you'll have to cut that check afterwards. If the deposition's canceled fewer than 8 calendar days before the deposition date, then the doctor will be entitled to 1 hour, $455, no matter what. I put in there a little comment about a distinction between being canceled and postponed. I would think that maybe instead of canceling a deposition, you postpone it, because the statute says canceled. It doesn't say postponed. You know, it's playing with the words there, but hey, that's what I get paid to do. Okay, So moving on now to review of SubRosa recordings. So this is also an area where hourly billing is still allowed. Interestingly, they allow $455 per hour for doctors for deposition, but for SubRosa, inexplicably, it's $325 per hour, or the physician's rate, whichever is less, which you'll never see. Anytime a physician bills under this, they have to submit a declaration verifying the time that they actually spent reviewing the SubRosa film. Be careful with this. I literally just had a report come back and a bill where we gave the doctor about 6 hours of SubRosa recording, really good ones, by the way, fun. But the doctor billed for 10 hours of SubRosa recording, and that doesn't make sense. That's actually why the declaration requirement is here. It's here, again, the DWC is trying very hard to be objective with what they're doing. So we're gonna have to knock that guy's bill down a little bit. He's, billing inappropriately. So, and down at the bottom here, I also made a comment. The SubRosa the SubRosa review charge is different from the supplemental supplemental report. So if the doctor also issues a supplemental report, he may charge $650 separately for the report, and that is in addition to the hourly fee for actually reviewing the SubRosa video. Okay, so now the meat and potatoes and the the vegetables, I guess, of the new statute. This is the part you don't like to eat. From now on, as I mentioned earlier, for comprehensive and follow-up examinations for page 201 and on, and for the supplemental examinations from page 51 on, a doctor may bill $3 for every page reviewed. So, sorry, I'm getting little notices here. I'm trying really hard to get rid of those. This is a big change, and this is the way I think the DWC contemplated making sure that the documents are properly doctors are properly compensated, while eliminating the complexity factors, which were, again, they were just kind of ambiguous and hard to put a finger on. It's easy to say $3 per page. This is one page, that's $3. Pretty simple, right? I've tuned into a couple DWC seminars, and the attorney there has said, that the parties need to act reasonably, doctors need to act reasonably. One of the attending physicians to those DWC meetings is a doctor named Dr. Lawrence Fywell, really good doctor. And Dr. Fywell understandably said, hey, if I get a document, I'm going to bill $3 for it. I don't care if it's a proof of service. I don't care if it's a cover page for a subpoena. I'm going to bill $3 a page because he's not limited by the statute. And further, how is he or she, how is the doctor going to know if the document is relevant unless they look at it? So again, I think it falls upon the parties, mostly the defense, to make sure that the documents being provided are not duplicative and are relevant. As I put here, the exact language from the statute basically says, for purposes of record review, a page is defined as an 8.5 by 11-inch single-sided document, chart or paper in physical or electronic form. It doesn't say it has to be relevant. It doesn't say it can't say, it can't be a flyer to a punk rock show. If it's a document, it's going to be charged by the doctor. So it's going to be important for the provider of the documents, that's you and me, hopefully, to be careful with what's provided. I mentioned earlier relevant documents. And when I think of record review and relevant documents, my first thoughts always go to Kaiser Records. And God bless Kaiser, they do great work. But their documents are ridiculous. I just reviewed 675 pages of documents the other day, which probably could have been boiled down to 100 pages easy of relevant information. And I put it even in here in my presentation, at the end of every date of service on a Kaiser record, they have one full page called the end of encounter page. So, if you have, 50 encounters, that's $50 for nothing. So it's going to be important for the defense in particular to cull the documents down to something that's relevant and, again, not duplicative. The problem with this are our counterparts on the other side. And I'm not saying everyone. I have a fantastic working relationship with 90% of applicants' attorneys. I think everybody sees the utility of working together. It just makes sense in our business. But there are those who don't adhere to that philosophy. I could name names, but I'm not going to. And I think I'm worried that some of them are going to try to use this as a bargaining chip. And the problem with it for the defense side is that there's really nothing holding the applicant's attorney's feet to the fire. They could just basically send off whatever documents they want, subject to a declaration, which we'll talk about. But there's nothing that says that they can't send whatever they want to send. So I think it's going to be important for the defense attorneys when the case is litigated, and for adjusters to reach out and say, okay, let's be smart about this. Let's send an appropriate amount of reports that are relevant and documents which are relevant, and let's not have us defendants send 1,000 pages and you applicant also send 1,000 pages. That's that's $3,000 right there for essentially nothing. The DWC attorney said that the parties really need to agree on what is to be sent, but there's no statutory mandate for a meet and confer or for anything else. Under Labor Code 4062.3, when you use an AAME, the parties are supposed to work out what documents are going to be sent to the AME, but it's not a requirement, and there's no meet and confer requirement. So I'm concerned that we're going to have cases where we reach out to the applicant's attorneys and they say, hey, we're sending 5,000 pages of records, and we're going to want to limit that. What do? I think, again, this is just kind of my initial thought process on this, and I think it's going to be borne out as the statute's more developed. But I think we're going to have to file for an expedited hearing, or potentially do a petition to stay provision of the documents or stay the evaluation until such time as a judge can look at it and say, okay, you guys all calm down now. I'm here to make a decision. These are the appropriate records to be sent. As an aside, I guarantee no judge wants to do that. But in some cases where you have uncooperative opposing counsel, you're just going to have to do it. And again, I hope that's the minority, but I see it happening. Okay, moving on. I told you there was a lot of information. Okay, so declarations. Now the parties providing documents have to submit a declaration, which we'll talk about in a second, and doctors similarly have to submit a declaration back to the parties whenever a report is issued. So the statute says, when billing under this code, the physician shall include in the report a verification under penalty of perjury of the total number of pages of records reviewed by the physician. Now, interestingly, if this declaration is not provided, the doctor cannot be paid for that record review. They could be paid for the flat rate of the report, but they cannot be paid for the $3 per page review. So in here I put no declaration, no remuneration. And as I've said before, my English 101 professor is certainly proud of me and my ability to alliterate. But again, the serious point is that if they don't give you a declaration, you don't pay them. It's always tricky when you don't pay the Q.M.E. Maybe you tell them, hey, doc, let us know the precise amounts of records you reviewed so you can get paid. But be careful of that, because it's also subject to abuse. For example, real quick aside, just this week, I had a doctor who issued a declaration saying that he reviewed, I think it was just under 100 pages, but he billed over $4,000 extra for it. So, the doctors are going to push the limits, not all of them, but there's going to be a lot of them that are going to push the limits to try and get paid as much as possible. It's going to be up to you and your bill review to make sure that they're doing what they're supposed to be doing and keeping to a reasonable amount for pages reviewed. And that reasonable amount should reflect the amount of pages you provided them as stated in your declaration or in the declaration of the provider of documents. So now, in my opinion, this is something where the party must do it, because the party really needs to go through the documents and sort them out. I don't believe it's a copy services obligation. I don't think you should farm it out to a copy service or something, or some other entity like that, because they don't know the nuance of the case like you do or like I do. So the provider of the document is supposed to issue this declaration. I suggest it's you. I know it's a pain in the butt. You have a lot to do already. I get it. But here, I'm gonna carve up this statute a little bit, just because I think it's really important. And I know we're getting close to the end here, and I've talked a lot, and I probably need a drink of water. But just to break this one down, this is, again, the declaration that the provider has to submit. And on this slide, I just say it references that the provider of the documents, it's not the defendant, it's not the attorney, it's the document provider. So that's you or whomever is actually sending the documents. The declaration also requires that the provider state that he or she has complied with the provisions of Labor Code 4062.3. 4062.3, among other things, provides that you give time for service. So you have to send the documents at least 20 days in advance of any Q.M.E. evaluation, and allow the other side at least 10 days to object to any of the documents that were sent. So when you sign your declaration, you have to say, yes, I've complied with this provision of the code. Importantly, the statute says that this declaration should be done before providing the documents to the physician. So what I've been doing is I put my declaration and attestation on top, and then have the records below and send that off to the doctor. And then it must contain the attestation as to the total page count. And again, this is where you want to make sure that the page count that you provide the doctor lines up with the page count the doctor is saying he reviewed in the doctor's declaration. So you got to match them to make sure that they're not trying to overbill, which is going to happen, by the way. Again, any records that are oh no, strike that. I take that back. The point here is that if there's no declaration from you, we talked about if there's no declaration from the doctor, you don't have to pay the doctor. If there's no declaration from the provider of documents, then the doctor is not obligated to review those documents. It's as though they weren't available to him or her. So again, the declaration is really important, just to make sure that you extend the statutory duty to the doctor to actually review the records that you've provided. Okay, we got a few minutes left, and we're going to get into the modifier. So this is, in addition to the page review, this is another scary little portion of the new regulations. I kind of touched on it earlier, and it's kind of self-explanatory. But for any time you use any of these services which are set forth here, you have to increase the flat rate only by whatever's included. So for example, using a psychologist, psychiatrist, you would double it times 100%. So you got $2,015 for a comprehensive medical evaluation. That's $4,030 right off the top. And I'm sure you guys have used psychologists before, and I can't remember one time where I only got one report from a psychologist. And I also can't remember a time when the report was less than 50 pages. That's a different story. But the problem is, and again, the thing I'm worried about is I think there's going to be a lot more psychological add-ons, even if it's not for PD, even if it's only for treatment. And it's going to substantially drive up litigation costs. Again, one evaluation, and that's one evaluation assuming that there's no substantial record review, is going to be doubled. I should also be clear that the modifiers only apply to the base rate. They do not apply to the $3 per page charge. So if you got $3,000 in record review, you don't double it. It only applies to those 3 base rates that we talked about earlier. The one other thing about the modifiers is that they can be combined. So if you have an interpreter and you're also utilizing an AME, then you're going to be multiplying the report by 45%. If it's also a psych report, a psych AME with an interpreter, I mean, you're multiplying that report by 145%. So more than doubling the flat rate. So that's going to increase costs pretty substantially. And again, this is where I talk about the psych thing. All right, the last little bit I'm going to talk about right now, and then maybe I can take some questions if there's any, if there have been any. Maybe I put you to sleep, I don't know, or maybe you had to turn me off because I've had too much coffee. But whatever the case, it's the last point I want to emphasize is the critical nature of explanations of review. I know that sometimes as adjusters, you may not have control over this. And for my, if there's any physicians or any other people attending, I apologize. This isn't necessarily meant for you. This is definitely for the adjusting side. I would just say this, with any bill dispute that you may run into now, forever, even back then, make sure the EOR is clear and specific. The EOR is the document, of course, that explains why you're disputing a charge. Critically, it's also the evidence that we're going to take to the judge. And judges do not like an EOR, which is like a kitchen sink EOR, where it says, the doctor overbilled, the declaration was inaccurate, the pages were muddy. I don't know, whatever the basis is, make sure that the EOR only includes the critical and relevant objections. That's going to help us if we go to court and we present an EOR to a judge, which is like a template EOR with everything tossed in. The judge isn't going to rely on it as evidence. It's not going to have the same kind of credibility as it would if it is specific to the issue. So Labor Code 4622 is still going to apply on this, and this is again our evidence to defend you guys. So please be clear with your EORs. I know sometimes you don't draft them and that they come from your bill review company, but when you can, please review them and make sure they're clear. It helps you, it helps us. And that's about it. So that's ooh, I didn't mean to do that. This is man, that's how the sausage is made right here. Okay, let me get back to that. Good. Okay, back to the first page. And I'm going to go back to this page right here. And I think Diane's going to join us back right now, or Tammy, or somebody help me.
Bill, I have a question. I just want to see if it's been covered. I don't believe it has been covered. So will this eliminate Labor Code section 4622 for disputes?
No, in fact, it won't. And it might eliminate some of the disputes, because under Labor Code 4622 is the way to object to for a non-IBR, non-bill review issue. So was the payment late, for example, is a non-IBR issue. That's still obviously going to apply. There's still the requirements. And I did a whole other training on this about the time frame that you have to respond with your EOR, actually. But no, this is not going to eliminate 4622 disputes. It should reduce them, because now we have a more objective criteria for billing, but there's still going to be 4622 disputes. So please be aware when you're sending payments that you're adhering to those timelines, or you could get nailed.
And then my next question would be, how does one file an abuse report?
Okay, and I'm assuming that question is referring to a doctor. I think it's going to be important to do with this. Contact the administrative director or the medical unit if you see a pattern from a doctor. We all know our doctors in this business. We spend a lot of time reading their reports. Some are great, some are terrible. And it's when you see a pattern from a doctor, I would suggest reporting them and saying, look, this doctor continuously overbills. It's not justified. They're not following the process. Just let the administrative director know, or let the medical unit know. They're in charge of meting out discipline to doctors. But I think it's going to be important, because the doctors gained a massive benefit in this new fee schedule. And I would say that most of their lobbying efforts were pretty impressive, because most of the changes benefit them, understandably. But we also got to kind of keep their feet to the fire and make sure that they're not doing, as I just encountered, overbilling when it's not justified.
We had a question. We had a question when somebody was asking whether or not the defense can insist on an in-person evaluation. Is that something that can be done?
Well, that's a very good question, and it's been strange because of COVID, and I'm assuming that's the foundation for this question. So I do. And I've insisted, it may mean you have to get multiple panels. It may mean that the selection process lasts a little bit longer. As we slowly open up, and as society opens up again, hopefully this will be less and less of a problem. But I would never want an applicant that I'm involved with evaluated on an orthopedic claim via telehealth or online or not in person. It matters so much for the straight leg test, for example. You can't really get the gravity of a straight leg test if you're in your room, and there's also it's also subject to abuse. The one exception I would say is that where I've been comfortable with it is for psych evaluations. Psych evaluations, there's no depression bone to measure. It's just you guys talking, or the applicant and the doctor talking. So I have no problem with telehealth there. As far as orthopedic, to answer your question, yes, I would say that you are well within your rights to demand an in-person evaluation. If the applicant or the applicant's attorney is giving you grief about it, I think it's appropriate to go to a judge and say, Judge, this doctor's not agreeing to do an in-person evaluation. Please issue a replacement panel.
And can you remind us what they're to do when in an advocacy letter if the Q.M.E. does not address the issue being requested? What is the procedure that they should follow after that?
Okay, so if I get it right, so then that means that I think this is what you're asking, is that the PQME did not address a specific issue previously requested, right?
That's correct.
Okay, so under those circumstances, what I would do is if I'm an adjuster or have your attorney send a letter to the doctor, and politely, you don't want to anger the doctors. It's a delicate dance we must do, because we want to get favorable reports, but we also want fairness. So what I would do is I would send a gentle reminder to the doctor and say, Doctor, you're so smart and you're so brilliant and your analysis is so spot on, but somehow it must be your secretary's fault. You missed this issue that we asked about. So kindly issue a supplemental report in which you specifically address this issue. If you want to make sure that the doctor is, happy, if potentially maybe there's another issue that the doctor could address that would allow for them to bill a supplemental report, and that way there's not the contention. But if the doctor is failing at this, and remember, this happened all the time before, where we'd get a report and we'd be like, all right, the dude didn't address apportionment, or we didn't get this, and then we'd have to get a supplemental report, and it cost a bunch of money. So if they're doing that, then yes, doctor, you didn't address this, you need to issue this. And just as a reminder, we asked you this in this correspondence, or this advocacy letter dated, whatever it was, stated this, and you didn't. As such, we anticipate that you'll be kind enough to issue a report and not bill us for it. Good luck with that, by the way. But that's the statutory basis. But again, it's that delicate dance where you have to enforce your rights while at the same time not making the QME mad at you.
Well, we have a question from an examiner. It says, how do I know as an examiner if the treatment of an eye injury could potentially affect the injury or medical problem of a lower extremity? And I think this is a matter of them pulling out relevant information to provide it to the doctor.
Wow, that's a pretty crazy. Maybe if the person's looking over at their back, they'll strain their eye. It is that is one of the problems with getting the documentation, the relevant documentation, to the doctors. And here's the thing. So under that circumstance, say that there might be a link or something the doctor something the doctor believes is relevant. If you don't provide the eye information for a lumbar spine, is that going to somehow undermine the report as substantial medical evidence? I don't think so. I think they're distinct enough under that example to be different. But what if it's a lower back and a hip, or something that's a little bit more closely related? Under those circumstances, you may want to provide the records to the doctor just to make sure that it's comprehensive and that the report you get is going to constitute substantial medical evidence. If it's something like the eye and something like the lower back, I mean, I suppose there's a way they could be related, but I think you'd be safe in maybe not sending the eye information because it's really not necessarily relevant to the orthopedic. I think it's a matter of judgment for you. You know, that's as case handlers, we all know the facts of our cases better than anybody. Maybe within that, there's some sort of fact or some pattern which makes you think, okay, I think the doctor should look at the eye stuff, even though he or she's examining the orthopedic. So ultimately, and this is probably the standard lawyer answer to a question, is it depends. And that's kind of a cop-out. I'm not meaning it to be. But I think it really depends on the type of case you have and how you know your case. And if that didn't answer your question, there's my email address. We can go back and forth, and I'll be happy to try and clarify.
I'd also like to state that MacroPro has nurses on staff that can help with that type of issue. They can review the records and tell you whether or not something is relevant. So there are outside sources if you needed to do that. And of course, your attorneys can go through it and decide what's relevant as well. Tammy, can you come back on with us?
Sure. Hi.
Hi. So we are at time, but I wanted to be sure to thank Tammy and Bill very much for this presentation. It is very timely. I know there are so many questions. If you have any additional questions, you can certainly email Tammy, Bill, or myself, and I will make sure that they get that. As a reminder, I wanted to let you know that your certificate should come to you within the next 2 hours via email through GoToWebinar. So please be sure to look at that. We'd like to thank you both very much for being here and for our audience, and we will see you at the next MacroPro and Friends, which will be next Thursday, and it'll be on brain injury. All right, everybody, have a great day. Talk with you later. Bye-bye now.
Bye.
Thank you.